I don't have any response to the motion.
That's because I didn't realize I needed to do a response, and I wasn't even served with this court date.
Sorry?
I said I didn't realize I needed to do a response, and I wasn't even served with this court date. He was like, "Oh, I'll see you at court," and I was like, "Oh, there's court." I have to prove it.
Okay, well, for some reason, there was a permission to serve the motion by mail.
Yeah,
she was served.
I never received for this court date today.
It was signed for, so.
I received stuff back in April, but not for the new court date they made for today.
All right. I'm going to put the matter out 2 weeks, 4th of June at the same time. You need to get a response filed and served right away.
That's no problem. Can I have permission to?
Oh, I'm sorry, it'd be the 5th.
Can I have permission to serve by mail? Because I live in Vancouver. Otherwise,
Yeah, you can serve your response by mail.
Thank you.
All right, so be back here on the 5th at 9 o'clock.
Thank you.
We have, I see Mr. Dice there. Can you hear me, sir?
Yes, sir.
And do we have Narcissa Dice?
I've been having trouble getting her served. I tried the sheriff's department and a process server, and neither one of them could get her.
All right. I'll put it out 3 weeks to June 12th. You will need to do a new order to show cause with that date on it, but we can't do anything until we've got her served. You understand that?
Is there any way I can serve her by mail?
If you serve her by mail, there's very little I can do by way of enforcing an order. She basically can't be held in contempt, can't be ordered into court. So you're better off trying to get her served in person.
Okay. What was that date again?
The 12th of June, 9 o'clock.
All right. Thank you.
And the state have any position on this matter?
We're not involved, Your Honor.
All right. Okay, ma'am. Let's see. Did you submit proposed parenting plan? Let me look here.
Alienating from my child the last April 14th.
Your Honor, are you aware that Mr. Evans is on Zoom?
Mr. Evans? Are you there, sir? Okay, you need to unmute your phone. Mr. Evans? Yeah, I can't hear anything from you. Mr. Evans, have you filed any sort of a response to this? I don't have one. Okay, here's what we're going to do. I'm going to continue this matter 2 weeks. That will be to June the 5th at 9 o'clock. Mr. Evans, I strongly suggest you appear in person, and you need to get a response filed and served on Ms. Norris immediately. Do you understand that?
Can I get a visit or something? She was with me for almost 2 months, and then he just took her from me.
You know, I understand the concern. I agree with the concern. And given the technical issues, unfortunately, I don't think there's much I can do today. I would strongly suggest that you both try and work out some aspects of the parenting ahead of time. You'd both be much better off if you can come to an agreement rather than me just imposing something on you. You understand that, sir? Okay. So the 5th at 9 o'clock, ma'am. All right, thank you. And we'll hang on to your proposed orders.
Your Honor, Noel McLean appearing on behalf of the petitioner, Roy Daly.
All right, Mr. McLean, it's your client's motion.
Yes, Your Honor. Thank you very much. So we were here a couple of weeks ago, at which time my client had not provided proof of service. And even though Ms. Nielsen was present, the court set this matter over to today. We did file on May 9th the proof of the personal service as well as mailed service on Ms. Nielsen. That took place on April 27th. And as I indicated, she was present 2 weeks ago. The temporary order that was entered back on November 14th of 2023 allows for supervised visitation at paragraph 14. There is no provision in there that allows Ms. Nielsen or the supervisor to unilaterally terminate visitation. But Ms. Nielsen took it upon herself to terminate my client's visitation commencing February 23rd. And she did not allow visits until the parties were back in court on April 24th. That's when visits did resume. Coincidentally, when she denied visits on February 23rd, 4 days later, she filed a notice of intent to relocate, although that had not been properly served on my client. So I would suggest that that does suggest that there's some ulterior motives here. Ms. Nielsen acknowledges in her declaration that she unilaterally denied visitation. There is no evidence that Mr. Daly was under the influence. There's no evidence from the supervisor about any issues at the visitation that was terminated by Ms. Nielsen. I've reached out to Ms. Hargrave, but unfortunately she's not returned my calls at this point. Visits have now been supervised for 6 months with no expansion. My client has complied with the substance abuse evaluation. Those records were filed with the court, and that was a collateralized evaluation. There was no recommendation for treatment and no significant issues found as it relates to Mr. Daly. So at this point, his visits are currently every Wednesday for 2 hours supervised and every Saturday for 4 hours supervised. When Ms. Nielsen unilaterally terminated visitation, that resulted in my client missing 9 Saturdays or 36 hours and 8 Wednesdays or 16 hours. So we're asking that the court allow for makeup visitation of 52 hours. We're asking for the expansion on Saturdays, that those visits extend to 8 hours from 10 a.m. to 6 p.m. for the next 13 weeks. Quite frankly, since there's been 6 months of supervised visitation, really, I think that this matter needs to proceed to unsupervised visitation because that's a lot of responsibility and time for a supervisor. And again, there's been no information to suggest that any of the visits have been inappropriate. So we're asking that the court enter a finding of contempt, award the makeup visitation. We're also asking for the court to order $300 in sanctions and $750 in attorney's fees. I have provided a proposed contempt hearing order for the court.
Ms. Nielsen, is there anything you wish to say?
Yes. In the parenting plan that I went and filed after I stopped visitations, it does show 2 sets of photos with Roy and Paisley. In one set of photos, it shows that he is high.
I would object at this point because, one, this is outside the scope of her reply declaration. And I'm not aware of any references relative to photos or what those may show.
Okay, well, I'll allow her a little bit of freedom at this point. Go ahead, ma'am.
In one set of photos, it shows that he is high. And then the other set of photos, it shows that he is high and had some alcohol in his system. I did stop the visitations due to the incident back in March of 2023, when he had been under the influence as well and brought out a gun with my daughter present in my arms. I felt that he had been putting her life at risk showing up to visitations like that. Now, the last visitation that he had back in February of this year, I had to go and drop off her diaper bag because the supervisor forgot her diaper bag at my house. And upon dropping it off, his eyes, I noticed, were pink. And usually when they're pink, he is under the influence. Now, I was with him for 7 years, so seeing his demeanor and the facial expressions he has when he is under the influence, you catch on to those really well. So I felt that I needed to stop visitation so that her life wasn't being put at risk. Now, when we had court on the 24th and the judge said to resume visitations until further notice, I did go back and continue visitations from that point on. I have been speaking with the investigator on everything and speaking with the supervisor, Tara, and in communication,
We are not objectors to
Sarah
any hearsay, and again, there's no declarations from the supervisor here.
I understand that, and we're getting well beyond the issue of the contempt right now, so let's focus on that. Ms. Nielsen, anything else you want to say?
I have been speaking with the supervisor the last few days as it is, and have asked her to write a declaration involving the visitations.
All right, here's where we're at. This is a real short, simple, easy issue. You may have had some concern about Mr. Daly's appearance. You're not entitled to, on your own, decide you're not going to follow the court-ordered parenting plan. If you think it needs to be changed, you file a motion asking to do that. But you don't decide yourself whether or not you're going to follow the parenting plan. That's real simple. Do you understand that?
Yes, Your Honor, that was my misunderstanding.
I am going to find contempt. That's very clear. The civil penalty of $300 is appropriate.
Your Honor, I am on TANF and going to school currently. I'm limited on what they provide me with every month.
Well, that's my concern. All right, I'm not going to order fees. I am going to order the civil penalty. The visits currently are 2 hours. Is that right?
2 hours on Wednesdays and 4, although those days fluctuate depending upon agreements between the supervisor and my client, and then 4 hours on Saturdays.
All right. Moving forward, the Saturday visits are going to change to 6 hours by way of an attempt at makeup visits. I don't want to put any more burden than I have to on the supervisor. And
so currently the hours I think are noon to, I think it's noon to 4, so noon to 6.
Ms. Nielsen, do you have any idea of the supervisor's schedule?
She, during the week, the reason why they're 2 hours on Wednesday is because she gets off at, I believe, 5.
Okay, what about Saturdays? Do you have any idea what her schedule is?
Saturdays, from what I understand, are open for the most part. She does help her daughter out with feeding horses in the morning and at night.
Okay, let's go noon to 6.
And then I have a question, Your Honor. After those hours are made up, do they go back to noon to 4?
Well, there's an awful lot of other issues going on in this case right now. I suspect that things will change before we get to that point. Excuse me. However, yes, so adding 2 hours, that's what, 26 visits?
Okay.
So I'm indicating Saturday visits.
This is at paragraph 9 in the contempt order. So 12
Leave
noon.
it at, yeah, I'm changing it to noon to 6 p.m.
And then instead of saying through 8/17, just provide for 26 visits.
Yes,
And then will you strike at paragraph 8 the lawyer fee?
yes, ma'am.
And then at paragraph 1 also the lawyer fee.
Yes.
Is the court willing to reserve those?
Not at this point.
Okay.
You can see where we stand in the balance of the litigation.
And then at paragraph 11A2, would you strike the attorney fee? The language of the attorney fee?
Yes,
And
I
then
just
I will-
and attorney's fees and leave the sanction.
Okay. And then I'll provide Ms. Nielsen with a conformed copy by email. The last time we were before Judge Evans, I was asked to provide Ms. Nielsen with an email agreement so that we could serve each other by email. I've not yet received signatures from her on that, so I need her to cooperate in
Yeah,
signing.
I had a question for you on that.
Why don't you reach out to me by phone rather than here through court?
Okay, I wasn't sure if I
Call
was
Ms.
supposed to
Call
sign
Ms.
it.
McLean's office and you can discuss what your concerns are.
Thank you.
That'll be all.
Morning, Your Honor.
And we have Desiree Camp. Okay, so there was a prior contempt finding when Ms. Camba didn't appear. However, the motion was served by mail. There is an order allowing service by mail, but it only allowed service of the summons and petition, not a motion for contempt. It was limited in the order. So at this point, we don't have proper service on Ms. Camba. You understand that, sir?
She's left the state and has been gone, and I haven't seen my son since like September. So, yeah, I don't really know. They just having me come back to see this, and I'd like to see my son, and I have custody of my son, but she's gone and is hiding with him, and yeah, so I'd like to see what it is that we can do about this, because
At this point, there is an order regarding the parenting plan, and if she has left the state without with the child, I'm going to suggest you contact the police. Right now, I can't do anything one way or the other until she's served with your contempt motion.
I did contact the police, Longview Police Department, and they said that they had to wait till court today. So, just here to see what it is that's going to happen now that I am at court, what the next steps are, because, like I said, I haven't seen my son in almost a year.
I understand that. As I said, there's a temporary parenting plan in place, but she hasn't been properly served with a motion for contempt. So I can't do anything in that regard, and I have to strike the prior finding of contempt. You understand that?
I'm supposed to serve her if she's gone.
I'm sorry?
How am I supposed to serve her if she's gone?
I understand what you're saying. I can't do anything in this civil case until she's served with it. That's why I suggest you contact the police at this point.
I did contact the police, and they said that we had court today. So
let them know what happened today. But unless and until she's served, I can't order her to do anything.
So I can't serve her by mail?
No, sir.
So how am I I really don't understand because you guys just have me coming.
If you don't, I can't do anything to her unless she's got notice of this hearing. You're telling me she's left the state and you don't know where she is. So that means we can't allow service by mail because we don't know where to mail it to.
Well,
so either you've got to have the police or investigator find her so we can serve her, or go through the police and see if they're willing to pursue matters. Those are the only options I've got for you.
So I did go to the police, and that's enough. I should just call the police department and let them know, hey, it's okay to find her now.
Let the police know what happened today. You understand?
Yeah.
All right.
So nothing happened today, right?
Yeah, I can't do anything because she hasn't been served, and you can't serve her because you don't know where she is. Let them know all that.
Okay.
Oh. All right. Thank you, sir.
I'm not sure if you can hear me. I have my headphones in right now. I'm at a doctor's appointment.
Yes, I can hear you.
Okay, thank you.
Your Honor, wanted to just bring it to the court that I was not served with Mr. Gareth Clark's paperwork.
In the clerk's office, they just told me who I had to serve, and that's what I did. And so if I needed to serve her, I didn't know I had to. I know I served the state, so.
Okay, well, Miss Lawrence is a party in this case, so she has to be served with any motion like this.
Okay.
All right.
If it makes it any easier, I think I'm prepared to continue, though, Your Honor, if you've read all three of those reports.
And I don't have any response from Miss Brooks.
I'm Ms. Brooks, and I didn't. I was going to submit them yesterday.
Miss Brooks, I can't understand anything you're saying. You need to hold your phone in one position and speak a little more slowly.
Okay, can you hear me?
That's better.
Okay, so I got the papers served from Tamara Sharp Garrett's mom on the 3rd. I didn't really have any time to respond as I was waiting for declarations from other friends and family on my behalf and things that involved Gareth.
Okay, let me stop you a second. So if you got served on the 3rd, today's the 22nd. That's plenty of time to respond. Okay. What I'm gonna do in an excess of caution is I'm putting this over 1 week.
Thank you. I'll have those in today.
You need to listen to me. You need to get all those responses filed and served by tomorrow.
Yes, I'll have that done today.
Man, you need to listen, please. You need to get those filed and served on Mr. Clark and on Ms. Lawrence by tomorrow. You understand that?
Yes.
And we will be back here the 29th at 9 o'clock.
Okay.
Can I say something by chance?
I'm sorry. Okay.
Can I say something by chance?
Yes, sir.
So I haven't seen my kids since October 6th of my birthday, and I was seeing my kids Friday through Monday, and like they just got shut off of seeing their dad, and I was hoping like to at least be able to for like just the week, be able to have a day where I can see them because I haven't seen them for a long time. So.
All right, we're going to address it next week. I'm going to strongly suggest to both of you that you come to court in person because neither of your connections are very good at all, and it's very hard to understand what you're trying to tell me. So you might want to come to court in person.
Okay, what courtroom would that be?
I don't know. When you come to court, there'll be a sign that tells you.
All right, thank you.
Thank you. Bye.
Your Honor.
Yeah.
And has the child been returned?
Yes.
Yes.
And Ms. Young, it looks like you still haven't filed any sort of response. Is that right?
Yes, I did. I responded and I turned it into the courts and I served Cameron.
Let me look here. Oh, okay, there it is.
So, Your Honor.
Hang on just a second.
Okay.
Okay, so let me ask Mr. Miller, from your standpoint, are both parties now following the parenting plan?
As of what do you mean by that? Because as of right now, yeah, my daughter's with me with the restraining order that restrains Taylor from me. But the paperwork that Taylor served me with, I have no case numbers on anything. The only thing that I technically have.
Okay, Mr. Miller, I need you to listen to my question and answer my question. At this point, as far as you are concerned, are both parties following the parenting plan?
Yeah.
Okay. Ms. Young, from your standpoint right now, are both parties following the parenting?
No.
And in what respect?
There's a restraining order, so that keeps me from seeing her. And before he got the restraining order and all of this, he refused to let me have her. He kept her from me.
Ma'am, I need you to listen to my question and answer my question. As of right now, are both parties following the parenting?
Yes.
Okay. Ms. Corey? Where are we?
So in the last hearing, Mr. Miller was directed by the court to get a hair follicle test. I do not see that has been filed, nor have I received it.
And Mr. Miller, what's going on with that?
So with that, for one, I don't know where to go get a hair follicle. And for two, I was talking to lawyers and they said that that's not technically fair because it goes back to 6 months when I'm already on. Okay.
Mr. Miller?
It goes back 6
Mr. Miller?
months. Yeah.
You were here on the 8th.
Yes, I'm aware of that.
And the judge ordered you to get a hair follicle.
Where do you go get one?
If you can't figure that out, that causes me a lot of concern about your abilities as a parent.
I know where to go get a UA at.
Well, why don't you call them and ask them if they can do a hair follicle, if they can tell you where to go get it?
Okay, I'll do that. Okay, so my concern now is that the guardian ad litem was taken off of the case, and the next step of this parenting plan is to go to mediation, not to have the guardian ad litem weasel her way back in. So, and then my other concern is that she also talked to my child without a court order.
Okay, A, the guardian ad litem's in the case until a court says otherwise. B, I'm not the least, Mr. Miller, you really need to listen. I am not the least concerned about the guardian, quote, weaseling her way back in. I need her input. That's why they are appointed. At this point, what we've got is you haven't done what you've been ordered to do, and that needs to happen immediately. Do you understand that?
Yes, and I'll be filing a petition to get a new guardian ad litem.
You are free to file anything you want to file and to note it on. In the meantime, this is over till next week at 9 o'clock. If we don't have that hair follicle in hand by then, there's going to have to be some changes made to the parenting plan. Do you understand that?
Yep.
Do you have any question about that?
Not at all.
Ms. Corey, anything further from you?
Yes, actually. I was relieved of this case because of Mr. Miller's adamant decision not to pay me. He said in court that he was not going to pay me, that he did not pay for things until he received them, and that meant that he wasn't going to pay me. I did actually have the order appointing and submitted that to the school the only time I spoke with his daughter.
Okay. So, Mr. Miller, your approach is to all of this is doing you some pretty significant harm right now. I suggest you look very carefully at what you want to actually get out of this case and make some changes immediately. Is that understood? Your attitude, your approach is endangering your time with your child. Do you understand that?
Oh, I do.
Okay.
I don't feel like the guardian ad litem's looking at both sides equally. She's looking at Taylor's side.
Mr. Miller, did you hear what I said?
I'm understanding what you're saying.
All right. We will be back here next week, the 29th. We will have the hair follicle test in hand. I strongly suggest you change your approach to the guardian ad litem between now and then.
I'm going to file for a new one.
You're free to do that. And whoever the judge is will, I'm sure, look at it. In the meantime, we're going to be listening to Miss Corey carefully and what she has to say. And you need to be aware of that. Miss Young, you had a question?
Yes, two things. Can he get a new guardian ad litem? I paid Miss Corey in full.
Mm-hmm.
I paid the whole $1,600 for her to be my GAL.
Okay.
Second, there's still a restraining order. I would like that removed so I can speak to my child. I want to ask Cameron if she's been in school. I don't know anything.
Let me stop you. If you've got a motion that you want to make, you need to file that motion, serve Mr. Miller with it, and get it noted on so we can address it. You understand that?
Okay, is there any way you can drop the restraining order?
If you file a motion, it will be considered.
Okay.
All right. Over to the 29th at 9 o'clock.
Or can I have at least a phone call? They did that last time. If I could at least talk to her on the phone. So she doesn't think I'm just completely gone. Because I don't know what he or anyone's been telling her.
It's not like you allowed me to do that when you took her from me.
Mr. Miller, you guys are not going to sit and argue with each other in the middle of this. And Mr. Miller, you also need to sign a release of information to Miss Corey. That's got to be done before the 29th as well. You understands that?
Yep.
All right. 29th at 9 o'clock.
Was that a yes to a phone call, Your Honor?
See you on the 29th, Your Honor.
We will address that on the 29th as well, ma'am.
Okay.
Okay, let me see here. Yeah, this one has a number of documents that also weren't showing.
President, Your Honor.
Good morning. Yeah, there's a whole batch of documents that are filed here, and I was trying to determine on this one. Like I said, there's a number of documents that are in the court file that I haven't had a chance to look at because they're not yet viewable.
So the state's involved?
Not at this time. We are just looking at the fact that there was an adequate cause motion filed, and I just wasn't sure if, Your Honor, if that was what was being heard today. Because I couldn't view documents.
It looks like that's scheduled for June 26th.
Okay.
What's the adequate cause?
I have no idea, sir. I haven't seen those documents. They've been filed, but they're not. There's a petition to modify, which I don't. I think there's. Like I said, I don't have those documents in front of me, so I don't know what that's about. And I was trying to determine what we were doing here today. It was put over from the 22nd.
Cameron's supposed to show a hair follicle test, and that is the modification filed for the 21st. I think it said, or 26th. It's a completely different court date.
So I don't see anything filed that was from the hearing on the 22nd. It looks like there was a request. Commissioner Warning had indicated he
The
was
hair
sending it
part.
over to file some things.
So I
Cameron's
did
supposed
get
to
the
come with the hair follicle test, and we were supposed to address the situation with Malaya and my contempt in the restraining order.
So, Your Honor, I did get the hair particle test done at LabCorp. I need the guardian of the item's information so I can sign a release of information to her. So I need her to email me her information so I can call LabCorp and sign a release of information.
Ms. Corey, I think you're involved in this case.
She was out. She said that she would be out of town for this court case.
Actually, I am.
Hi.
I am sort of involved, Your Honor. It's been kind of a rough road. I was actually dismissed last year because Mr. Miller refused to pay me. I've been trying to collect that amount for over a year now.
I need you to email me your information.
Has your email changed? Is it the same one that I have?
Cameron 25. Cameron with the K.
So it looks to me like there's a whole bunch of, again, there's a number of papers that have been filed set for, looks like it's June 26th. And
So
again,
I don't even have any of those papers.
I understand that. So they haven't been filed here. We don't have them in the court file yet. I can see that they've been filed at the front counter, but they're not showing up here. I assume those are on their way to you as well. But that'll need to be dealt with. It looks like on the 26th of June, assuming that that's served timely. So at this point, it sounds like there's a number of things that I just had this on for a review, and it was unclear to me why that was on. And then I saw these file documents. So I guess my thought is maybe we put this over to the 26th. Mr. Miller, you can get your information, take care of your contacts with Ms. Corey. Ms. Corey, you can send him your email. Hopefully we can get that all addressed, and then we'll have the rest of this up in front of us. I was trying to look through the notes from the last hearing. So it sounds like there was a hair follicle. It sounds like that may be done. That needs to be sent to Ms. Corey. There's something about a restraining order in here, which
Yes, there's a restraining order, which I would like you to see if you could revoke, because on the 8th, the paper says that it was only temporary. And the judge moved it over another week because he needed a hair follicle test. He did not provide the hair follicle test. So they kept the restraining order and pushed it over another week. And again, we still don't have the hair follicle test. And I would love if you could take that away so I can speak and see my child, because now I've done everything I'm supposed to do, and Cameron has continued to not do what he's supposed to do, and I still am not able to see my child. I filed all the paperwork. He was served. I can talk about it now. And now it's going on almost a month of me not seeing my child again. I don't even know if she's in school. I keep getting messages saying that she has absences. So I don't know if she hasn't been in school the last almost 3 weeks or what's going on. I have no idea what is going on.
Can I say something, Your Honor?
well, I'm trying to find that order. It looks like there was an immediate order that was entered April 11th, which would have been good through 5/8.
It was supposed to expire on the 8th, but they kept pushing it because he didn't come with his hair follicle.
Well, like I said, when I looked through this, I couldn't find that order because on the 8th of May, it looks like the notes indicate that the restraining order would remain, but there's no order extending.
Because on my paperwork, it says it would have expired on the 8th unless they extended it. So if that's happening, is there any way for you to take it away now, since it was technically supposed to be expired on the 8th, so I can talk and see my child? Because now I go from having her, Cameron being in jail, to me not even being able to speak to her. And there is no reason why I should not be able to speak or see my child. Especially that,
Your Honor.
that Cameron has.
Okay, hold on, ma'am. Just say, what's your position on that, Mr. Miller, about her being able to speak with the child?
If you allow her, I would like it to be supervised because I've had Malaya for 5 years, and then I got incarcerated, took care of my warrants, and then that's where Lewis County told Taylor that she could have Malaya on her weekends and our parenting plan still stays into effect. But Miss Young did not follow the parenting plan. She decided to keep her. She decided to hide her. She took Malaya out of her school for weeks because I was on the hunt to get my kid and to serve her.
Your Honor.
Can I finish, please?
One at a time, please.
And then so once I did find her, I had Thurston County looking for her. I had Centralia Police. I had Lewis County Sheriffs, Pierce County Sheriffs looking for her. And Taylor took Malaya from the house that they were sleeping at. They took her down south to Centralia, to Thurston County, back up to Pierce County. Malaya's been with me primarily the whole time except for 3 months. Now, with that, my daughter does tell me stories about how her Mima, which would be Taylor's mother, would tell Malaya to hide, get down low in the car, because your dad's around here somewhere in the same area that I live. And so when I found her, Malaya starts telling me all of these crazy stories. So if you allow Taylor to see Malaya or to talk to her, I would like them to be supervised, please.
Your Honor.
Well, hold on just a second. What I've got is, again, this case is kind of a mess because there's, it looks like the parenting plan that I'm looking at is from September of 23. Okay.
Correct.
He is the primary parent, so he has essentially custody in the case. There was an order, a restraining order entered, which would have prohibited your contact, and that happened back in April of this year. That order would have expired on the 8th. It appears that Judge Evans extended that, but there was no order entered doing that. So at this point, there's no, I guess here, and that now we have a whole bunch of new documents filed. It looks like maybe for, again, I don't know what those are all about. It's obviously some sort of modification of the parenting plan. And whether or not that'll be addressed or not will depend upon whether there's adequate cause. Again, that's not in front of me today. That'll be heard on the 26th. It would make sense to me at this point, with what little I know, which is not a lot, and Ms. Corey's getting back involved, it sounds like maybe at some point or not.
I really would not like to continue on this case. Mr. Miller expressed vehemently during the last hearing that he did not want me on the case. But if he does get appointed a guardian ad litem, I would suggest that he be required to pay up front.
Okay. Well, here's my thought on this. Right now, Mr. Miller, you're the primary parent, correct?
Correct.
And there's a child with you? Or
yes, sir.
Okay.
I do want to state that she is in school too.
Okay. So
and he switched her into school without my consent, which that's contempt in our parenting plan.
Okay. So it looks like there's a lot of things happening in this case. It's going to be back in front of the court on the 26th. In the meantime, what I'm going to do here, give me just a second, because I don't want us to get into a situation where there's nothing.
Your Honor, may I say something?
Sure.
I don't believe there should be supervised visits. Before this, we had a parenting plan and things have changed significantly. He was in jail for multiple charges that were unsettling to me. And he got a restraining order on me for my child. I went from having her to not having her at all. And now this person has her, won't let me see her, speak to her, nothing. And he's not worrying about the mental well-being of my child because she didn't want to go with him in the first place. And me not being able to see or speak to her just because he feels a type of way is not right. They should be supervised because right before that, when he made his decisions of domestic violence and his obstructing law enforcement,
hold on.
He was not thinking of our child.
Okay, I don't have all of this in front of me, and
I filed those like a month ago at this point. And every time they say, the first court date it was, he didn't have his paperwork. The next one, he didn't have his hair follicle test. No one's looking at my paperwork because if they did look at the paperwork, they would know that everything Cameron's saying is a lie. I've put proven facts and evidence that he is lying under perjury and under oath. And no one.
I'm not actually.
Okay, hold on, both of you. I have a declaration that you filed 3rd, May, 2023, which responds to the 2023 May 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 2023 the temporary order. And I don't know if Judge Evans looked at that on the 8th or not. There was a discussion about not a bunch of documents not being served. I have no idea what those are because it's not clear to me from the court record what was filed. There is a new matter that may move forward depending upon adequate cause. Currently, your parenting plan that was entered last fall is the parenting plan that's from September of 23. That's the parenting plan that's in place currently. And he has primary residential care of the child. There was that immediate order that was entered. She's responded to that at some level. Again, it looks, there's a lot of notes in here, but there's no paperwork as to what I don't know. It's Mr. Miller, did you receive that declaration from May 3rd?
Which one?
She filed a declaration. It says it's 26 pages long. It's handwritten. It's mainly includes some Lewis County guardianship documents, or at least a denied order.
Yeah, I
That
got all
was for
that.
when he was in
Okay.
jail and I had her because he went to file for contempt, which this is what this hearing's about. But how can I be in contempt if he's been incarcerated for 4 months and a court order gave her to me? There was no way I
Okay.
could talk to him or anything.
Okay, so here's what I'm going to do. The parenting plan that's from September is the current parenting plan.
Unless we could stick with the parenting plan until the court date of the 26th, so I at least have her for the weekends.
So at this point, there's no order modifying the parenting plan. So the parenting plan that's currently in effect is the parenting plan before the court. When I look at what Mr. Miller filed, it was an immediate restraining order, but there would need to be some sort of modification of the parenting plan case filed. And that's, at least I don't have anything in this file. There is, as I indicated, it looks like, and I assume this is, mother has filed a new petition to modify that's not been served. It's not in the court.
Yeah, I just did that, yeah.
Okay, it's not before the court at this point. So at this juncture, your parenting plan from September of last year is the parenting plan that you need to follow. So
Okay.
whatever the terms of that are is what you both need to follow until somebody files and the court hears something that changes that order.
So can you take the restraining order away?
Well, just listen, okay?
Your Honor.
Sir, I just need to have you listen for a second. Okay, you've not filed something to change that parenting plan. You filed an immediate restraining order, but that doesn't change the parenting plan.
Yeah, I understand that.
I'm talking to him right now. So your parenting plan from September is the parenting plan that's in effect. She's now filed some documents. I'm not looking at those because I don't have those. You don't have those. I'm assuming asking to change the parenting plan. You'll get those. You can either respond to that or you can file something to change the parenting plan from last September. Because that's the parenting plan you've got, and nobody has got anything that's properly before the court to make a change to that plan, to modify it. So that's the parenting plan you need to follow. And what I'm signing an order here today is you need to follow that plan. The restraining order that was in place, it looks like it expired on the 8th, and I don't know if Judge Evans may have extended it verbally, but he did not. From what I can see here, that was not re-extended on the 22nd. So
Okay, so can we do supervised visitations? Because if she doesn't,
Sir?
No.
Sir, you need to file
Taylor,
something.
stop talking, please.
But you both need to just listen, okay?
And
Nobody
what about
has
if she
got
doesn't
any,
give her back?
sir, nobody has filed anything to change the terms of the parenting plan, which was what it would take for me to impose supervised visits. And again, Ms. Young, if you have the visits that are set on the plan and you don't return the child as ordered, then you're looking at likely some potentially even criminal charges. So you need to make sure that you both follow the parenting plan until we get a proper legal paperwork that gets it back in front of myself or another judge to make a change to that parenting plan.
Yes, Your Honor.
And that means if she's got visits that are set out, those need to be followed. And if you've got the visits, the child needs to be returned at the end of it.
Yes.
So that's the order I'm signing right now. And then when we, you'll get, again, it looks like you got a bunch of paperwork that's on the way, sir. We'll be back on the 26th. If that's been properly served and it's timely, we'll address that. You can file something yourself if you want to make a change, but at this point, your parenting plan from September of 2023 is a parenting plan you both need to follow. So that'll be my order I'm signing today, clerk. And as far as everything else, I really it seems to me that we need to probably come back on the 26th, see if there's grounds to make a change, but there may or may not be. I don't know that. I haven't got all that information, either what she's saying or what your response to that'll be. But in the meantime,
is involved.
I'm sorry?
But the state's involved?
If the state's involved, it would be at the level of child support if there is either a change of primary residence or some other reason to change support. And again, that's not in front of me today. I'm not changing the parenting plan that's currently in place. So the parenting plan
will do in exchange on Friday.
I'm talking about for the 26th, because wasn't that first lady representing the state?
Your Honor, I can clarify that. We would only need to be involved if adequate cause is granted at that hearing. And as we're not discussing that today, we don't know what that decision is. The state is not involved at this time, but we would be involved regarding child support only if adequate cause is found to change the parenting plan, as that may change what child support currently looks like.
Okay, thank you.
And I have no idea whether whichever judge hears this on the 29th will make a finding of adequate cause. I don't know that because I don't have that paperwork in front of me. And obviously you have a chance to respond to that before that's found.
Yes, Your Honor.
All right,
So where do you want
your current parenting plan, which is the one from September of last year, is the one you both need to follow.
Okay, and since he no longer lives in Longview, is there another exchange point we can do on Friday?
No, I'll meet you at Gigi's truck stop.
Your parenting plan that's currently in place is what you both need to follow.
Okay.
So I'll meet you at Gigi's truck stop.
Okay, at 6 o'clock.
All right. So that's all
Never
for today.
show up.
So that is all for today. I've signed that order requiring you both to follow that parenting plan.
Thank you, Your Honor.
Thank you.
Okay, you're welcome.
Right here, Your Honor.
Okay, welcome, Mr. Miller. And is Taylor Young on the line?
Yes, I'm here.
Okay, welcome to both of you. And I see that, let's see one moment. See that Ms. Corey is on the line with us also. Welcome to you. We're on today for Ms. Young's motion for adequate cause to modify our parenting plan. And let me just double check. As far as service, I had a question, Ms. Young.
Oh, yeah.
So let me just see who's speaking. Ms. Rhodes, Megan Rhodes. Can you please mute?
Yes, give me just one moment.
I'll take care of it. Thanks. Okay. So, yes.
So I need to go down to the courthouse, and I need to the court called me, I think about a week ago, and I need to switch. And I need to put my name as the petitioner and hers as like the respondent or something like that. And I still need to serve Miss Young. And then Miss Talia, if that's correct, I tried emailing you and contacting you to set payment up. And then, yeah, it's in an email somewhere. And then I also left you four voicemails. And then my hair particle coming from, who is that? LabCorp. They should have already emailed that to you too, out of Tumwater. Okay. Go ahead.
I've not received an email from you. I've not received an email from them.
Okay. I'll check up on that then.
I haven't received anything either.
I know I still need to serve you, and I need to go back down to the courthouse to switch paperwork around, they said.
Okay. So let me just kind of step in a bit. We're here on Ms. Young's motion for adequate cause to modify the parenting plan. I wanted to first check with Ms. Young as far as service. Did you serve a copy of the summons and the petition to modify on Mr. Miller or to Mr.
Yes, and he threw them in my stepmom's face.
Could you say that again?
He threw them in my stepmom's face and never responded.
Okay. And did you file an affidavit or declaration of service that
Yes.
documents were served?
So none of that is true
So
because
hold on, Mr. Miller. So, Ms. Young, what I'm looking at on June 3rd, I see an affidavit or a declaration of proof of personal service. It says Angelia Barton served Mr. Miller on May 31st, 2 documents, a proposed parenting plan and a motion for adequate cause.
Yes.
What I don't see on that is that there was no service of the summons and the petition, which are necessary to move forward with any type of motion. So
I filled everything in with it and the proof of service.
So on the proof of service, it indicates that it says Mr. Miller threw the papers across the parking lot, but there's only 2 documents that are shown that were served upon him, the proposed parenting plan and the motion for adequate cause. So the boxes that the petition and the summons, those are not marked. And so when I read that, that tells me that he didn't get all the documents. So procedurally, we can't move forward today because he hasn't been properly served with those documents. And that's probably pretty frustrating for you because you go through a lot of effort to get things done. But at this point, we're not in a position to move forward with your motion for adequate cause and to modify the parenting plan.
Even if it's also been 3 weeks, more than multiple times, he hasn't responded with his hair follicle or anything.
Okay.
They keep pushing it and pushing it. There has to be some kind of consequence for him not doing what he's supposed to do.
So going back to the hair follicle, can you remind me the date that was ordered?
He's already ordered it.
And Ms. Corey, you may be able to know also.
Your Honor, the hair follicle is done. If LabCorp hasn't sent that over, I can't control that. All I can do is call them and have it sent it over. That's it, but it's done.
So when did you take the hair follicle?
3 weeks ago.
What date? What date did you take the hair follicle?
I'm looking. It would have been the 4th or the 5th.
Of June? Okay. Ms. Corey?
It was ordered on May 22nd by Judge Warning.
Okay, so it was an oral order.
I believe so.
Okay, so let's see.
Under the 522 motion hearing.
Okay, so on May 22nd indicates the clerk's minutes say the court sets the matter over to May 29th at 9 a.m. The hair follicle test to be provided by then. So on May 29th, we had a hearing, and that was in front of Judge Bashor. There's a discussion about the hair follicle test. Mr. Miller requesting the GAL to email her information so he can submit an ROI. GAL to provide information to Mr. Miller. Hair follicle test needs to be sent to the GAL. So this was discussed previously, from Mr. Miller. Did you send a copy as instructed and discussed by the court on May 29th?
I gave provider all of the information for them to do it.
Did you send a copy to all the parties? That's kind of the key part. We don't care what the others are doing. The onus and responsibility is on you.
Correct. No, I didn't.
Why not?
Because I thought that they were going to reach out and send it to her.
So when the clerk minutes say that Mr. Miller needs to send the hair follicle test to the GAL, what part of that do you not understand?
I thought I was supposed to give them her information and sign a release of information for her.
That was part of the discussion. Yeah.
Yeah. So then that's where I got messed up in.
So, Mr. Miller, are you in a position today to get a copy of the hair follicle results and email and also mail to Ms. Corey and to Ms. Young?
Yeah.
Okay, that's a court order that you'll accomplish that today. I'll do a bench order so there's no confusion. One moment. Do you need any email addresses to send or physical addresses to send that information, Mr. Miller?
Just the GALs.
Okay, Ms. Corey, can you share that?
Certainly. It's
Are you able to email it to me?
I have emailed it to you. Most recent email was May 29th.
Okay, I'll look for it.
Okay, so Mr. Miller, just so you're aware with the order that I'm writing or just wrote, it says Mr. Miller shall forward a copy of the hair follicle test taken on or about June 4th or June 5th, 2024 to Ms. Young and to the GAL by close of business today. Any questions on that order?
As of like close to business today?
You have to do it today. You have to send it today. It has to be completed by the end of today.
Okay, so I'm at work right now.
Would tomorrow be easier, better?
Yeah,
okay.
Please.
So I'll amend that so it'll read June 27th. Okay, so that takes care of the hair follicle issue, Ms. Corey. Did you, or was that Mr. Young that spoke?
Oh, it's me. I was like, so do I need to go serve him another summons for the modification, or can you put, since he's here now, can we discuss a date for the summons or do I need to reserve him again?
Yeah, so the issue with service of all the documents for the adequate cause motion and the parenting plan modification, sometimes it's service is uncertain when and where that'll occur. So generally we don't set a date in the future. We wait for the service to occur. And then when you're doing the service, then you'd set a docket notice and setting it to a particular date. So I'll leave that in your hands to make a determination of what date that should be. And then then the documents can be served upon Mr. Miller.
Yeah, that's what we did when I did. I'm the one who set the 26th and the 12th for him to respond by the 12th. I did all that. That's why I didn't know that the papers weren't turned in, because I picked the date and everything.
Right, like I said before, there's 2 documents that were absent in the documents served upon Mr. Miller. So all those same documents he served before, and then the addition of the petition and the summons also have to be served upon him, and then give the date for the future. Okay.
Your Honor.
Yes.
With all the difficulties she's had with serving him, is it possible that she can serve him by mail? I believe that was approved.
Yeah, I don't think that, so the prior service was in person, and there's Mr. I believe.
He served me by mail the first time. He just dropped it off at my mom's house and they used that.
I'm just looking for a pleading filed by Mr. Miller so we know his address.
It's there.
Okay, I've got a Rochester address. Mr. Miller, is that the correct address?
Yes, Your Honor.
Okay, and it looks like it's on, like, is it?
Yeah.
Yep, okay. Yeah, so Ms. Young, that's fine if you want to serve via mail, so you can mail that to that particular address, and then Mr. Miller will be on the lookout for those documents so you can get them, and then you can respond in writing to, so I know what your position is.
Am I also able to mail her or email her for my response?
Yep, that's fine. And you'll see that with the pleadings that she's filed, and it looks like it's.
Yeah.
Okay. Other items to address today, Ms. Corey? Okay. I didn't hear you, but I read your lips and it said nope. It looks like you're unmuted, so I'm not sure what happened. And then Ms. Young, any other items on your end?
Oh, there's no other court date. It's just when I make a new court date.
Correct. And then Mr. Miller, any further items on your end?
No.
Okay. I appreciate you getting
And
that
one more
follicle
thing.
test forwarded to Ms. Corey and to Ms. Young.
One more thing.
Yes.
And on the pickup and drop off, we're not in Cowlitz anymore. Can we move the drop off and pick up somewhere up here? He lives in Rochester and I'm in Centralia. We're driving 45 minutes away just to turn around and come back.
I would rather not.
So anytime issues with, there's a request to change a parenting plan or a provision of a parenting plan, there needs to be some type of written motion with notice to the other side. And so I'd encourage you at this point to see if you can talk about it and come to an agreement. If you can't, then there could be a motion and that could be addressed in the motion to modify the parenting plan also. So sorry, I can't help you on that one today. There just has to be that notice and opportunity to respond. Okay. All right. That'll conclude the hearing for today. Thank you.
Thank you.
We need to get a GAL appointed in this case immediately. Well, at the end of this proceeding, the clerk's going to provide the names of 3 potential guardians ad litem that we've got to get involved in this case. You're each allowed to strike one of those 2, or you can agree on one. So she'll give that to you. Why don't you wait out in the lobby and go ahead. Okay, you want it done in here now? Okay. All right. Okay, so who are the three names?
Looks like Miss Karen Lawrence, Beth Fellows, Heather Kale.
Do you have any preference amongst those three, sir?
No, I do not.
Okay. How about you, ma'am?
No.
Okay, we'll just use Miss Lawrence then. And if you go out to the clerk's office, after you leave here, you can get her contact information. You both need to contact her right away. We're also going to need information on both of your finances so we can sort out how this is going to get paid for. And they can explain that to you in the clerk's office. In the meantime, all right, sir, what is your position?
I just want full custody of my son.
And ma'am, what's your position?
50-50 custody rights of our son.
I'm sorry, I couldn't understand you.
50-50 custody rights of our son.
And where is the other gentleman? Is he in custody at this time?
Randall Kearns.
Pardon?
Who's the other gentleman?
Your former boyfriend.
He was convicted and sentenced.
So he's in prison now?
Yes.
Okay. So how long has it been since you've had contact with your child?
Since December 25th, 2023.
Okay. All right, so I'm not going to make any change in the current restraining order until we get the guardian ad litem involved. So, as I said, both of you go out to the clerk's office, get the contact information for her. Right now, I'm going to say are you employed, sir?
Yes.
And where do you work?
Fisher Construction Group.
What kind of money do you make there?
I make $26 an hour.
Okay. And are you employed, ma'am?
I'm a full-time student.
Okay. Right, so at this point, the order will be that the guardians ad litem fees will be paid 30% by the father, 10% by the mother, and 60% by the county. I'm not sure if that's going to stay that way until we get all the financial information from both of you, but that will let us get the case proceeding. So you need to contact her right away. I'm going to put this out 30 days. We need to be back here on June 25th at 9 o'clock. And then based on whatever information we got from the guardian ad litem at that point, we'll try and make some decision about where we go with the parenting.
Be the 26th, John.
Oh, sorry, I keep looking at that. So June 26th, my apologies, 9 o'clock.
Can you please repeat her name again?
Karen Lawrence.
Karen Lawrence. All right.
So we have Mr. Warmdahl present and Ms. Mierendorf present and Ms. Lawrence, the guardian ad litem, is on the line also with us today. So we're here for a couple of different matters. There's Mr. Warmdahl's motion for temporary parenting plan that's we're here for on that, and also discussion related to restraining order and also the GAL and looking at some dates and the like. So it looks like maybe we could start with that first, with the guardian ad litem issue first. Ms. Lawrence was appointed on May 22nd. And I'm not sure from your vantage point, Ms. Lawrence, are you needing any information related to dates or due dates or anything of that nature?
No, it's going to take probably pretty close to 8 weeks at this point before I get things back from DSHS, considering the current workload that they have, what they're telling us. But both clients have met with me at this point, and we have already started the investigation and stuff. But basically, I could note it up, or if the court wants to set a date, that's fine too.
Okay, thanks. Appreciate that. So as far as both parties have commented on the proposed parenting plan. You both have submitted your input and what you'd like to see or not see related to the parenting plan. Ms. Lawrence hasn't had full opportunity to review documents and the like to provide additional input regarding the parenting plan. So I just want to ask you both what your position is, and we'll start with you, Mr. Warmdahl, since this is your motion for the temporary parenting plan. If you feel like it's important that there be a ruling on this now related to parenting plan, or if we should wait until we get more information through DSHS and also Ms. Lawrence.
I don't mind waiting for Miss Lawrence at all.
Okay. Right now, what's happening with the parenting time? How are y'all working that?
Currently I just have my son and
That's it.
that's it.
Okay. All right. Thanks, Ms. Mierdorf.
I would, sorry, I would like to see my son, anything, like an hour. I don't, just anything. It's been too long.
Right.
I just want to see him.
Okay. So the restraining order was signed March 20th, 2024, and that was based on some preliminary information about the other child's passing in last February of 2023. And there was restraints placed upon Ms. Mierendorf not to assault, not to disturb peace, and the like. So it sounds like Mr. Mierendorf's main concern, well, I'm not sure. I guess what I'm leaning towards at this point is that there could be some. I want to just address parenting plan kind of on an interim basis now to maybe give a little more clarity and fine point on the potential visitation between mom and child, and then have that be in place until we come back in 2 months, 2.5 months after Ms. Lawrence gets information. So that's kind of how I'd like to proceed today, if we could, since the motion's pending. There could be an interim ruling on Mr. Warmdahl's motion, and then we could have an additional hearing once we hear from Ms. Lawrence and the GAL. Do you have any concerns if we were to approach it that way, Mr. Warmdahl?
No.
Okay, Ms. Mierendorf? Ms. Lawrence?
Perfectly fine.
Okay. So let me just hear just briefly what your respective positions are, Mr. Mierendorf. Tell me what your concerns are and why an interim parenting plan should be one way or the other.
It should be one way or the other.
Well, your proposed parenting plan is that you have the custody of the child and that Ms. Mierendorf has no residential time or no visits with the child.
She could have visitations. I'm not completely opposed to that, but I would kind of like them to be supervised. I thought that she could still do supervised visits with her mom, but nothing has ever happened really.
Okay. And then, so to help me understand your concern related to safety. I understand that, I've read the police reports and the like, where Ms. Mierendorf was at work during the time when the child was assaulted, which eventually led to the child's death. And that was her boyfriend or significant other or spouse at the time. And tell me what your concerns are related to Ms. Mierendorf and being with your child.
It's not as much of a safety concern at all. It's just he goes to counseling and there's just, it's tied to her because it was her boyfriend and stuff. And he asked, where's Ducky and stuff like that. And he just is tied together with trauma. And it's not, I'm afraid she's physically going to hurt him. It's just, it brings back stuff and it hurts all of us in my household.
Mm-hmm. And you said the child's in counseling?
Yes.
How often does
he goes a couple times a month, probably. Like, he sees Connie.
And we're talking about Elias, right?
Yes.
And how is he, 3 or 4?
He's 4.
He's 4 years old now.
He'll be 5 at the end of this year.
Okay. And if Elias needed additional support, if the visits were started with mom, would you be in a position to make sure he gets to those appointments?
Yeah, I have a fairly busy schedule, but yeah.
Okay. All right. Thank you. Ms. Mierendorf, tell me what your position is. You've indicated that you're hoping for, I think, a 50-50 plan, maybe? Yes. And then, okay, why don't you go ahead and tell me what your thoughts are?
At the end of the day, it doesn't really matter to me what it is. I just want to see my son. I would like to do 50-50 because I just feel like all this is being based off of a crime that I did not commit. I didn't know. I'm sorry. And sorry. When my son was hurt, I didn't know. I would have done anything to prevent that from happening. I'm sorry that it happened, but I was working. I know I should have been home, but I just don't want to be blamed for something that I didn't do. I just want to see my son. It's not fair to me.
When was the last time that you had contact?
Christmas.
Christmas 2023. Okay. And as far as what's your input as far as supporting Elias if I were to allow visits? What do you think would help Elias?
I would like it to be unsupervised just because my mom isn't available all the time. She's only available for 1 day a week, and that's Sundays. And she's only available from 12 to 4.
Okay. And is Elias enrolled in daycare or preschool or Head Start? Okay.
I mean, he's enrolled, but he's not in it yet.
Okay, he's signed up.
Yeah.
Okay. And when does that start?
I have no idea. I gotta go through all my emails.
Okay. So, but he's not in it currently.
No.
Ms. Lawrence, do you have, I know this is very early in the process. Do you have any input at this point?
I don't have too much input because, as you said, I don't have all the information, but I think that it appears that there's no physical safety to the child. I agree that Ms. Mierendorf should be able to see her child, but trying to do that in a safe manner that makes Dad comfortable, because Dad got rattled too with all of that. It's a very frightening situation. It's a horribly sad situation all the way around. So I would advocate for visitation and what that could look like. I mean, maybe start out slow, but it could ramp up fairly quickly, I would think.
Okay. So I think what's important to highlight here is that there's no allegation or no allegation that Ms. Mierendorf is a danger or a physical risk to Elias. That there was a crime committed, a horrible crime that was committed. She was not present. She was not implicated. There was no charges brought against her. It was her boyfriend or significant other at the time, and he's serving prison time currently. So I think that's important to note at the outset. I think it's important also to note that Mr. Warmdahl is taking good steps to make sure Elias is supported with his mental health. I think that's really important. So good for you and good for Elias that that's happening. So I think what will happen between now and the next court hearing, which we'll set here in just a bit, the following residential time for mother. So I want to have 2 midweek visits or 2 visits during the afternoons from 4 to 8 p.m., one on Monday, one on Wednesday. And then another visit on Sundays from noon to 4. At this point, I don't think they need to be supervised. I recognize that there may be some big emotions from Elias that may be present. And, maybe that 4 hours doesn't happen the first time or the second time. Maybe it needs to be cut short. I don't know. But my sense here is that there's no physical danger. There's mental health support for Elias. And I think that should start this coming Sunday from noon to 4. And then it would begin the Monday and Wednesday, 4 to 8 p.m. And I'm just kind of throwing that out there initially. But my intent is to have 3 visits per week. With one on Sunday for sure. But the other 2 days, whether it's a Tuesday and a Thursday or a Monday and a Wednesday, I want to give you that flexibility as parents because I don't know your schedules and things happen. So any feedback on that proposed schedule, Mr. Warmdahl?
Weekdays being in the evening sounds okay, and Sunday is my day off, so.
Okay. All right. Ms. Mierendorf?
For the weekday for both visitations, if possible, can I request that just me and him for pickups and drop-offs?
Meaning you and Mr. Warmdahl?
Yeah, just me and him, no other people to come. His girlfriend just causes a lot of conflict.
Okay. Any concerns about that if we were to do that? Just that anytime that there's an exchange, it would be the you two meeting someplace, exchanging your child, and then going your separate ways.
Yeah, if that could be written in, that would be fine.
Okay. All right. I'll do that. Let me draft this so you each have a copy. That's what the order reads. This is an interim order related to residential time. Petitioner Warmdahl is deemed custodial parent. Respondent Mierendorf shall have residential time with a minor child on the following days and times: Monday 4 to 8 p.m., Wednesday 4 to 8 p.m., and Sunday noon to 4 p.m. At the exchange of the child, only the parents and child shall be present. So we'll give each of you a copy of that for your records. Let's look at a next date for us to come back. Ms. Lawrence has indicated 8 weeks minimum for records from DSHS to come back. So today's the 26th. That would put us to August, end of August, which would probably put us wisely to maybe September 18th or September 25th for the guardian ad litem report to be submitted. Any comments, Ms. Lawrence, on that? Is that too rapid of a turnaround after the 8 weeks?
I think that September 25th would work fine.
Okay. How about for the parties, Mr. Warmbell, to come back for the guardian ad litem to submit her report, provide you a copy, and come back to comment on it, see if there needs to be any adjustments to the parenting plan?
Yeah, on the 25th is fine.
25th September. Okay. Ms. Marendorf?
That's fine with me.
Okay. September 25th will be the date we come back. That'll be at 9 o'clock in the morning. Each of you will get a copy of the order. And again, the visits will start on this coming Sunday. So we'll see everybody then. Thanks.
Thank you, Your Honor.
Jennifer Schaefer,
Thank you.
Family Court Investigator, is also here.
Yes, ma'am. And let's start with Ms. Schaefer.
Yes, Your Honor.
Reports, what do you wish to tell me?
This was a tough one, as there are some concerns regarding both parents that I think need to be brought up as concerns. Mom is 1 year clean and sober, but has not had any contact with the children 3 years prior to this. The oldest son ran away due to child abuse, and was on the streets for 10 days and was able to reconnect with mom's side of the family. And both children have ran away from home and ended up in mom's care currently. I do have concerns about where the children should be, and I'm actually requesting that a guardian ad litem be appointed to kind of follow this case, as I was unable to get CPS records, all the school records, with such a short turnaround time.
So as far as you are aware, the kids are currently residing with the mother?
With the mother in an Oxford house, with plans to move in with her sister in Vancouver. They are currently enrolled in school in Vancouver under the McKinley-Vento Act. And up until recently, mom was transporting the kids without a valid driver's license and insurance 2 times a day back and forth from Portland to Vancouver, which was also concerning. But I've learned that she has since passed her driver's license test and now has a valid license. I'm still unsure if mother has insurance for them to be transported in the car back and forth.
Mr. Knuth, is there anything you wish to tell me?
I'm highly concerned with issues that I brought up regarding the aunt, where she's dropping them off in the day to catch the bus to school. And I don't understand how the act that she referred to is for children listed as runaways. They were not listed as runaways when they were enrolled in the school there. And there is concerns because the aunt that the mother's dropping them off with allowed my daughter to be sexually assaulted. He was the older sibling in this case, not one of the two involved. And I think with the fact that the boys have lived with me for the last 7 years to all of a sudden have zero contact, and what she's referring to as child abuse was already investigated by Child Protective Services and deemed unfounded.
And Ms. Schaefer, have you got any information on the boys at school attendance at this point?
I have started receiving some of the documentation. I haven't had that much time to go through it, as it's still all coming in, because it's coming from one of the children is under an IEP. So you're getting records from the IEP person, you're getting records from attendance, that type of sort of thing. But to answer Mr. Knuth, it was also because they are considered homeless currently, is also why they're able to be under that McKinley-Vento Act.
And best information you've got as far as school attendance? I realize
that they're attending, yes. They're extremely behind in credits and not working at a grade level, but they are attending.
All right. Ma'am, is there anything you wish to tell me?
Yes, I do have my driver's license now. I am getting insurance today. I have no idea where the sexual assault thing is coming from. There's never been a police report or any kind of evidence with that. The boys are still going great. I mean, they're going to school. Everything's good.
So are you living in an Oxford house right now?
Yes, I am.
Okay. And are the kids actually staying with you at the Oxford house?
Yes.
And are you intending to continue at the Oxford house or move?
No, I'm going to move in with my sister.
I'm sorry?
I'm going to move in with my sister.
When's that supposed to happen?
Like the next week.
How long have you been at the Oxford house?
I've been there almost a year.
Okay. And why are you moving out?
To be with family support, because my sister lives right next to my mom, and they're my main supporters right now.
All right. Well, we do need to get a guardian ad litem appointed. And who would the next ones be?
Beth Willows, Heather Kale, and Ann Hyde.
And sir, you have any preference amongst those?
No.
Yeah, ma'am, how about you?
No, sir.
Okay, the first one listed was Miss Fellows, and we'll appoint her. And did you hear what I was telling the people prior about go out to the clerk's office, get the contact information, and both of you need to get in touch with Miss Fellows right away.
I have one more question.
Yeah, give me just a second. Yes, sir.
At our last court date, I asked for a method to serve Kimberly because the method I used the first time will not work again, using members of the community that we've both known for over a decade. When I asked for a way to serve her, I was given a mailing address, and then I filed a motion, but didn't hear back on it in time to serve Kimberly via signed for mail. Can I get that just clarified, that if she's not going to give me the address where her and the children are residing, that I be allowed to serve her via certified mail?
Yeah.
What's the,
He can serve me by mail. It's fine.
okay, at the aunt's address?
No, at the address that I'm at now. You have pen and paper.
And if she's planning on moving out of there, that's going to be a temporary solution, not a. It would be really nice to know where my children are. And
Okay, at this point, if it's the Oxford House address, it stays that until there's a new address. You understand that, ma'am? So you're gonna have to arrange for somebody there to make sure you get the paperwork.
Okay.
Okay,
And with the Guardian at Litem, I only make $800 a month. Is there like a waiving fee?
well, that's my next question. We'll get to that. So
Okay.
do you have the Oxford House address?
not
It's
yet.
6705.
And with that being an Oregon address, is there anything special that I need to do to get her to do the service by mail?
No.
Okay, I know for the in-person, there was a different process if you serve in another state.
Understood. No, you can, from this point forward, mail any paperwork you need to serve her with to that address. So ma'am, if you move out of there, it's your responsibility to work something out with the Oxford House so you get that mail because it's assumed
Okay.
that you received it. You understand?
Yes.
Okay. So sir, are you employed?
Currently, I'm a stay-at-home parent.
You're
A stay-at-home parent.
okay.
I will be changing that in the near future, but
And you said you're making about 800 a month?
Yes, and I have to pay rent with that. Now I have to pay car insurance out of it also.
All right. So right now, this is going to be paid by the county, but that's going to be reviewed. Obviously, as we go along. So you both need to be aware of that.
Okay.
Okay. And June 26th then for review when we've got some information from the GAL. So I can't emphasize enough, both of you need to get that contact information out of the clerk's office, contact Ms. Fellows immediately. Understood?
Yes, sir.
Okay.
So, Your Honor, I have not been able to serve her because she has a protection order against me, and I and everybody in my family has absolutely no idea where she's staying at, and we have no idea like what her schedule is at her job. And every time I have tried to get somebody to go serve her, it's been impossible.
I suggest you go talk to the police.
I have, and they said they won't give me her address.
Okay. I'm not to give you the address, to have them serve her.
They said I have to have the address to give them for them in order for them to
Okay,
serve.
then you probably need to contact a private process server.
Okay.
All right, so we'll strike the matter for today. When you get that information, you can do a new order to show cause and get her served with that. Understood?
Okay.
All right. That's that.